For joining us today for the Your Will, a Plan for Care, Connection and Impact webinar featuring attorney Tiffany Gorton. I'm Cindy Sherrick, Director of Gift Planning at Seattle Foundation, and I'm pleased to be joined today by my colleague Natalie Pond, who's a gift planning advisor. I want to begin today by recognizing that the Seattle Foundation exists on land that is the traditional home of the Coast Salish people. We recognize them as the original and current stewards of the region.
Thank you so much, Cindy. I'm going to go ahead and just run us briefly through a few housekeeping items for our time today. First of all, everyone is muted and cameras are off to limit noise and disruptions. We are recording today's presentation, as you may have heard, and we'll send a link to that recording along with any supplemental materials from the presentation early next week. At the end of the program, we will have time for Q&A, which will be moderated by Cindy and myself. Some of you have already submitted questions. Thank you so much. I've got those ready to go. For any questions that do come up during the course of our program, please use the Q&A button, which is at the bottom of the screen, or it might be at the top if you're using a smartphone or tablet to join us today. We'll get to as many questions as we can during our time. This event does have a live transcript and closed captioning for accessibility. If you would like to turn this feature off or change the size on the closed captioning, you can do so by clicking the live transcript button, which is also at the bottom of the Zoom window. Finally, when you go to sign off of the webinar today, you'll be prompted to take a quick survey about your experience. We hope you'll take a few minutes to do this. It's so important to how we shape future events. And to sweeten the deal, for everyone who completes the survey, you'll be entered in a drawing to win a special Seattle prize. More on that next week as well. I'll go ahead and pass it back to Cindy to share a little bit about who we are at Seattle Foundation.
Thanks, Natalie. Seattle Foundation has been a trusted partner to thousands of community members since our inception in 1946. We know what it takes to bring a shared vision of a better community to life, expert knowledge, deep partnerships, and the tools that every smart philanthropist needs to make their most meaningful decisions and deliver the greatest impact. We currently have over 500 members of our Seattle Foundation's Changemaker Circle, and these people have entrusted Seattle Foundation to fulfill their philanthropic legacy through a bequest, a beneficiary designation, or a charitable trust, and we thank them for their faith. If you are part of Seattle Foundation's Changemaker Circle, we want to thank you. And if you're interested in joining, you're welcome to contact myself or Natalie after today's webinar.
All right, it's that time, and I'm very honored to be introducing our speaker, Tiffany Gorton. Tiffany Gorton is a partner at KHBB Law. She joined the firm in 2012, and her practice focuses primarily on trust and estate litigation, estate planning, and taxation. Prior to joining the firm, Tiffany was a tax associate in a boutique accounting firm with her practice focusing on estate, gift, and fiduciary taxation. Tiffany has worked as a part-time lecturer at the University of Washington School of Law, and she also serves as a volunteer attorney with the University of Washington Federal Tax Clinic, where she assists taxpayers in resolving disputes with the Internal Revenue Service. Tiffany has been designated by her peers as a rising star in both Super Lawyers Magazine and Seattle Met Magazine since 2014. Please join me in welcoming Tiffany Gorton.
Thank you so much, Natalie. And thank you, Cindy, as well for having me today. And thanks to all of you for being here. I've been super excited about this all week, chatting with both Cindy and Natalie offline. And we're excited that you're here today. So as you probably saw from some of the emails that you received and what, kind of had you sign up for this webinar, we're going to be talking about estate planning. Again, it is National Make a Will Month, so happy National Make a Will Month to everyone. We're going to talk about how to kind of begin the estate planning process, what that process looks like, some of the tools, kind of the foundational tools, and then also talk about estate taxes and some of the planning that goes into avoiding those, unless the Department of Revenue or Internal Revenue Service are some of your beloved, in which case you might not be as interested in the tax avoidance part. No, I'm just joking. The other pieces we're going to talk about kind of what probate is, how that sort of affects the actual planning process, and what that looks like here in Washington, and some of the times where folks, where I tell folks, at least think about making adjustments or considering whether adjustments are needed at varying times in life. And so with that, I'm going to share my screen so that you can see my slide deck. Okay, there we go. All right. So thinking about what estate planning issues to kind of consider as whether you're brand new to thinking about your plan or you're thinking about updates, et cetera. Some of the kind of the foundational issues that I want to talk about are outlined here. I always tell clients that I think one of the most important questions is, if you were incapacitated, who would you want to assist with finances, with healthcare decisions? If you have minor children, who would help with caring for them? And that's not necessarily under the terms of your will. That's more of a durable power of attorney issue. But that's one of the issues that oftentimes prompts folks to reach out. And one of the things that I tell clients repeatedly, I think that that is very, very important as a foundational issue and foundational piece of the plan, because it's something that takes effect when we're still living. Similarly, if you had a terminal illness or otherwise, do you, what are your kind of end of life wishes? Those are things that kind of all are housed under the durable power of attorney document that we'll talk about here in a little bit. But it's one of those things that I always want to flag for folks as they're having that estate planning conversation as kind of a global discussion. Similar, in addition to that, thinking about things, kind of more traditional things that you're probably thinking we're going to discuss today is, who do you want to be your beneficiaries at death? Who do you want to receive your assets? Are there charitable organizations that are part of your plan? Are there individuals? Is there some combination of both organizations and individuals that would be beneficiaries of your estate under your will or trust, as well as certain non-probate assets? Let me make sure that these are a little bit bigger. Okay. Oops. Back to that. Are there beneficiaries that you would want to benefit, but maybe you wouldn't necessarily want them to have direct access to the assets that they receive? Meaning, do you have either minors in your life or even, responsible adults that you say, you know what, I want to benefit these individuals, but I don't necessarily want them to have, just assets in their bank account that they can access for anything that they see fit. And that can be, children, grandchildren, other young people, or like I said, even adults that are, to your opinion, financially responsible, but you might want to have either some oversight or some other protections. We're going to talk a little bit about varying types of trusts that can be used to accomplish some of those goals. And in a similar vein, thinking about kind of that responsibility and thinking about assets being managed and responsibly administered for the benefit of your beneficiaries, thinking about following your death, who would you be able to rely on to administer your estate, or who could you rely on to serve as trustee of a trust for for a minor child or for some other beneficiary? And you want to think about either, individuals in your own lives that could make sense. Sometimes family members make sense. Sometimes a trusted family friend makes sense. And more, I'm seeing folks say, you know what, I don't want to burden, because this is a job, not necessarily just an honor. This is also a job. Folks are kind of the mind that they don't want to burden family members or friends. And so frequently I have clients who have, they have great people in their lives and they're financially responsible, et cetera. But for one reason or another, it just makes more sense to have a professional fiduciary serve in that role. And that's all right too. There is not one specific path for every single family or every single individual. So there's a lot of different options there. And a similar question there is there a fiduciary, either a person in your life or a professional that would make sense to assist with the financial piece in the event that you were to become incapacitated? So again, this is during life, if there were, circumstances to arise where you needed some assistance with the management of your finances, that's another fiduciary role to think about as part of your kind of global planning, is, who would help, who would be on deck, so to speak, in that situation. So I always joke and quote my friend Benjamin Franklin that there are two things that are certain in life, and that is death and taxes. So thinking today about what about estate taxes? So more and more, we're seeing this affect many clients because Washington has its own estate tax. What is the estate tax? It's a one-time transfer tax that's going to be due if a decedent's estate reaches a certain threshold level. And so in Washington, the estate tax exemption amount is $2,193,000. We'll talk more about that throughout this discussion, and you'll hear me refer to that $2 million figure. That's what I'm referring to. So it technically is $2,193,000, but for ease of conversation, I'm going to refer to the roughly $2 million figure. At the federal level, the estate tax exemption amount is currently 13.6 per person, and we have can effectively double that for married couples. And so the federal exemption amount is obviously significantly higher and doesn't affect nearly as many individuals or nearly as many estates. However, in Washington, just thinking about your own life and probably what you've seen in real estate values, particularly in King County, if you have, a piece of real estate in a retirement account or life insurance policy, which although we don't think about those as our assets because we don't spend our life insurance policies during life, those things are indeed counted for estate taxes. So thinking about kind of globally, all the assets that are in our purview, thinking about those figures from that perspective. So I just got a really good question. How does someone go about finding and engaging a suitable and competent professional fiduciary? So as I mentioned, when you're thinking about having someone serve as either agent for finances or executor under a will or trustee under a trust, that can be an individual that is in your own life, or it could be somebody that's a professional fiduciary. And in terms of how to find someone that could be suitable and that could be a good fit, there are a number of large bank trust departments. So that's, one avenue that works for some people. But there are also, particularly in our area, in the Puget Sound area, we have a number of professional fiduciary shops where they have, a team of folks, or some are solo practitioner type settings, or maybe there's a couple people. But by and large, there are teams of folks that their job is to serve as a fiduciary. So that's what they do all day, is serve as in those roles, either as agent for finances, as executor for estates, or as a trustee. And one of the good things about those outfits is they have oftentimes varying costs for the task that they're doing. And so some folks, this is more of an East Coast thing, but some folks will say, hey, can I, you're my attorney, can I hire you to do this? And my answer is always, yes, you can appoint me, but that's not the most cost-effective approach. And you want to look at kind of hourly rates of the professional fiduciary, what types of services, and they'll break out varying services. If you're having someone do bookkeeping services versus, some manual labor of cleaning out the shed, well, those those require different skill sets and are going to be appropriately charged at different rates. Similarly, a trustee who is meeting annually or quarterly with the financial advisor, meeting with the CPA, thinking through more strategic or technical issues related to either the administration of the trust, the administration of an estate, et cetera. Those would be at a higher rate because they're a more technical skill that's required and more technical position or job that's being done. And in terms of finding those, there are a number of them in our area, and I'm happy to provide a list of some of them, but even a Google search of, professional fiduciary in Seattle will probably pull up at least, 10 different hits of the same list that I would send out. So getting back to thinking about our estate tax issues. So we have the two varying exemption amounts. In King County, again, it's not easy, but it's easier to hit that threshold level than at the federal level. And so that's something that, as you're thinking about engaging, with estate planning, thinking about setting up your own plan, looking at all the assets that you have and really kind of making a list so that you can say, okay, I do have these insurance policies, I have these retirement accounts, I have this bank account, I have this investment account, these real estate parcels, et cetera, kind of gathering all your assets and thinking, do I rise to this threshold level? Do I need to ask them questions about estate tax planning as part of that, initial conversation? And in looking at what does it mean, when there's estate tax due? Well, in Washington, you can see there's a chart, and basically the percentage runs from 10% to 20%, depending on how large the estate is. And similarly, at the federal level, from 18% to 40%, again, based on what the taxable estate is. So it can be pretty significant in terms of the expense, but there are really a number of ways to plan around that tax. So there are a couple handfuls rather, of estates that do have an estate tax. I have clients frequently ask, but rarely end up going the route of, what if I change my domicile? What if I'm no longer a Washingtonian? Is there a state that I can move to so that I don't have to think about the state estate tax? And the answer is absolutely, because there's more there are more states without an estate tax than with, and so certainly that's an option. But it is, in my opinion, we live in the best place, so it's hard to actually make that transition. The other tax to think about is the federal gift tax. Washington does not have a gift tax. And so part of kind of that overall tax planning conversation is we think about, all right, we have the Washington state gift tax, we have the Washington state estate tax, we have the federal estate tax, and we also have the federal gift tax as, one of the components that we think about when we're doing an overall plan. And as a result, because we don't have a gift tax in Washington, and the exemption amount at the federal level is so high, that $13.61 million figure that that a couple slides ago, that federal estate tax is linked to the federal gift tax. And so what you gift during life is essentially chipping away, depending on the amount, will essentially chip away at your estate tax exemption amount. And then when you die, what is left over based on your lifetime gifts at the federal level is going to be the remaining exemption amount, is going to be your estate tax exemption amount. Now, we have kind of a couple questions surrounding the gift tax. What is it? It's a tax on a gift that you make during your lifetime to an individual or a trust for an individual, not to a charitable organization that qualifies for an unlimited deduction. But this is going to say, I'm giving $100,000 to my grandchildren or to my children or to my neighbor. There's an associated gift tax at the federal level related to those types of actual lifetime gifts. Now, there is an annual exclusion amount of $18,000 per person. So folks can make that $18,000 gift to as many individuals or entities for individuals as they would like. And when I say entity, I mean really trust. So you could do that all day long, and there's no reporting requirement at the federal level if it's less than $18,000 or at or less than $18,000 per person. And again, Washington doesn't have a gift tax, so no reporting for that here. Anything above that $18,000 for one given individual is going to be reportable on a gift tax return. That doesn't mean that there's gift tax associated with that actual gift. It just means that you report it. And like I said, if you are gifting above your annual exclusion amount, then anything above that is going to chip away at your lifetime exemption amount, which is your gift tax exemption amount during life, and then whatever remains is going to be your estate tax exemption amount at death. So if I give away $100,000 to an individual, then I have to do the math of the difference between 18,000 and what I gifted, and then I have to report the rest of that gift. But again, no gift tax. There's again no gift tax in Washington. There are one way that folks kind of get around or do some informed planning is related to medical and educational expenses. If you are making gifts on behalf of anyone, either directly to the educational institution or the healthcare providing institution, those are not going to be counted as gifts that are going to be reportable or chip away at your exclusion amount. So they can be above that $18,000 annual gift if you want to, you're paying for your children's college education or similar, as long as you make those gifts directly or make those payments directly to the educational institution, it's not going to chip away at your gift tax exemption. Whereas if you put, $25,000 in child number one's bank account so that they can make the payment to the school of their choice, then you've made an actual $25,000 gift to that child rather than writing that check for $25,000 to the entity. The annual exclusion for married couples, again, that's essentially each person has that 18,000 annual exclusion amount. So my husband's name is Nick. I can gift 18,000 to any individual I want. Nick can gift 18,000 to any individual he wants. And that way we effectively double that annual exclusion amount in the same way that we can think about the lifetime exemption amount being doubled as well. And one other thing that comes up frequently in Washington is deathbed gifts. And what that looks like I mentioned, there's no gift tax in Washington. And so a lot of times we'll see folks who are, at a certain age, or they have, an illness or something along those lines where they know that they're terminal. And so they say, I'm going to, make these significant gifts because I'm not going to live a lot longer and I'm not going to need these assets any longer. I want to make gifts during my life, shortly before death, so that I can get them out of my estate for estate tax purposes, because in Washington there's no gift tax. So I could, as a Washingtonian, I could, gift away all my assets, knowing that I was, close to dying, and then, turn around and my estate is significantly smaller or doesn't have any issue with regard to Washington's estate tax as a result of having made those lifetime gifts. One thing to think about before we get into durable powers of attorney is, I mentioned this with regard to the $18,000 annual exclusion as well as the exemption amounts, is each individual has that exemption amount. So in Washington, each individual has that $2 million lifetime exemption in terms of the estate tax. Each person has the federal exemption amount of about 13.61 million. Similarly, each individual has the ability to gift $18,000 as the annual gift tax exclusion amount. So that's per individual. And at the federal level, for estate tax purposes, I've mentioned that you can, for married couples, effectively double that number. And just to clarify what that really means is, at the federal level, we have what's called portability. So if something were to happen to me, I died, and my husband Nick survived me, he would be able to make an election to essentially port my exemption amount at the federal level. So he would effectively have his own 13.61 million and my 13.61 million in terms of his overall estate tax exemption amount, if this were to occur, in 2024. And that is one way to effectively plan among spouses with regard to maximizing the estate tax exemption. In Washington, we don't have that same portability mechanism. And so here, what we do in order for married couples to be able to, same scenario, for Nick to be able to take his $2 million exemption amount and also utilize my $2 million exemption amount to effectively, pass $4 million to future beneficiaries free of the estate tax, is utilizing trusts under your estate planning. And that can be a will that's built into it, or excuse me, that can be a trust that's built into a will, or another trust that's built into a revocable living trust, which we're going to talk about the differences with those tools here in a minute. But just know that you can effectively double those figures for married couples, but there's some planning and some steps that you have to take to actually avail yourself of that doubled amount, so to speak. Okay. And thinking kind of quickly about the varying documents that are kind of part of a foundational plan. Excuse me, I mentioned that the durable power of attorney, both for healthcare and finances, is something that I think is important because it's effective during your lifetime. It loses its effectiveness when you breathe your last breath. So it ends at death, and then the rest of your plan takes over at that point. But basically, this allows you to appoint someone. Typically, it's the other spouse if you're married. Oftentimes, it's an adult child. Sometimes it's a professional fiduciary or a family friend or anyone of your choosing that could step in and assist with financial issues, managing finances, and healthcare. Also, can be same person or different person for healthcare and finances, if you for some reason were unable to take care of these things yourself. And part of this, here we're just saying that we want somebody to be on deck for that. The requirements for these are they need to be signed, they need to be dated, and either acknowledged before a notary or signed by 2 witnesses. And this is in the presence of the principal, which is the person who's actually making the power of attorney. So if it's my power of attorney, I need either 2 witnesses or a notary to sign, and we need to all be in the presence of each other so that I can see that those witnesses have signed. They can see that I've signed as well. In thinking about this from a gifting perspective and a tax perspective, it's important to note that you can give very broad powers to your agent for finances, including gifting powers. And so what that looks like is, say something were to happen to me down the road and, I had dementia. And so as a result, my agent for finances had to step in and manage my finances and my healthcare because I was no longer able to do that. I was still living and, can live a long time in those circumstances, but I needed somebody to help me during life. So my agent who I've nominated or my power of attorney would step in and help. And because my power of attorney is so broadly drafted, it gives that person the ability to be able to do some tax planning. I mentioned that we sometimes think about deathbed gifts here in Washington, and an agent under power of attorney can be someone who can effect those types of gifts to reduce your estate for estate tax purposes, but it needs to be in your best interest, and it needs to be within kind of your overall plan. So it's not a circumstance where the agent would suddenly start making gifts to, their own family, even though they were complete strangers to my gifting plan when I was lucid and was managing my own finances. But for example, I, regularly give to ABC charity, and I regularly give to my children and grandchildren each year. And then my agent steps in, they would be able to continue making those gifts, and they would be able to make gifts of a size that could be impactful for reducing my estate for estate tax purposes, in addition to just kind of having, that person on deck to ensure that my own, financial life my mortgage is paid, my taxes are filed, all of the things I take care of now. In this scenario, that person would make sure that those were taken care of, but they also have the ability to do some tax planning if that's necessary. Okay, and thinking about kind of some of the other tools, we think about from a foundational perspective, will versus will versus revocable living trust. So we're going to talk about both of those because you have either a will-based plan or you have a revocable trust-based plan when you're thinking about your foundational estate planning pieces. And what I tell clients is 9.5 times out of 10, a will work very, very well for most Washingtonians. And what happens when you have a will is you essentially have the ability to appoint your executor. You can appoint guardians and conservators for minor children, if that's something that is, if you have minor children. And then, of course, you are able to direct where assets are going to go at death. So you essentially can, direct the carving up of assets and include your beneficiaries there. You can very similarly, under the terms of a revocable living trust, you are appointing a trustee, and that person would be charged with doing a lot of the same things that an executor would do. You can also include your beneficiaries there, carve up things after you're gone as to how you want your assets to flow. So they are what I like to say that, they're foundational estate planning pieces. And why would you choose one over the other? Well, we're going to talk a little bit about kind of what the will is and what it does, and then what the revocable living trust is, what it does, and why one might make sense over the other. So with a will, this is not something that's effective until death. So you think through how you want your assets to flow and who you want to serve as your executor, your personal representative. You express your wishes in your will, and then you sign it, and it's valid, and you continue living life, but it's not going to actually be effective until death. What happens with a will-based plan at death is I die, my will gets filed with the court. And depending on what assets I own, and what needs to be done, a probate may be opened which is essentially, the court formally appoints the executor that I've nominated in my will and distributes. That person is charged with gathering all of my assets, finding out who my creditors are, making sure that my final income tax return is filed, filing an estate tax return if my estate's large enough and warrants that. And then ultimately, paying creditors, paying taxes, and then making a distribution of those assets according to the terms of my will. So it's a roadmap that provides the executor the directions as to, where things go at my death. And the executor has the authority to essentially wind up my life in the way that you would wind up a business, by, pulling assets, pulling debts, making sure everyone's paid, and then making the ultimate final distributions. That's something that is in writing, signed by me as the testator, and then witnessed by 2 witnesses in my presence. The revocable living trust has a lot of the same functions, but it's a document that's really active during life. Again, it governs the distribution of your assets at death. But what happens with the revocable trust is I would be my own trustee initially, then I appoint a successor trustee, and that person would really step in if I were incapacitated during life. But in thinking about it from a kind of will substitute perspective, they also would step in and serve as the trustee after my death. And at that point, what they would need to do is effectively gather, okay, what assets does this trust own? Who are the successor beneficiaries? How do things get transferred to the varying beneficiaries at the end of the day? And a couple things about the revocable living trust. It's a common misconception that this is an actual tax savings vehicle. It's not. It doesn't change anything. If I set up a revocable living trust tomorrow and I title my assets in the name of the living trust, my house and, my bank account, et cetera, that doesn't take them out of my ownership in it for tax purposes. So for example, with regard to my real estate, I changed title on my house to my trust, and I still am going to have to pay my property taxes. I'm still going to, if I sell that house, I'm still going to have to pay the capital gains tax on, if I have had a gain on that sale. This type of trust, there are a lot of tax savings vehicle trusts, but this is not one of them. This is essentially a will substitute. It doesn't save me any estate taxes. Assets that are owned by my revocable living trust at my death are counted as part of my overall estate in the same way that they would be if they were just titled in my name and my assets were passing under a will. So that's an important distinction because that's something that comes up a lot as a question. And the other thing to kind of think about when you're thinking, well, would a will make sense for me, or would a revocable living trust make sense for me? I mentioned that 9.5 times out of 10, a will works very well for Washingtonians. And that's true because in Washington, our probate process is not particularly onerous. There are some states, like California, for example, where their probate process, that post-death court supervised administration of gathering the assets, paying the debts, and making the distributions, that process in their courts can be very onerous, it can be time consuming, and it's expensive. In Washington, you have a $240 filing fee, you file a will with the court appoints the executor, and the executor has the authority to act. And sometimes there are circumstances where there's a dispute among beneficiaries or something like that. That is not the norm. That is sort of the exception. But in circumstances where nobody's fighting about anything and it's a matter of, the executor carrying out the terms of the will, that is in and of itself, the probate process here is not a cause for real concern. Again, it's not an onerous process. If there are folks that are fighting about things, which, they can dispute among themselves with regard to a trust as well. But just in and of itself, the probate process here is not problematic or difficult or particularly expensive like it is in some other places. So my point is, oftentimes you'll hear folks saying, well, I really want to avoid probate. And if that's something that you want to do, which is totally okay, then a revocable living trust would be the tool to use versus the will. Why I say that most folks are very well served here in Washington with a will is because the probate process isn't particularly problematic. If you have a will at death and you are going through the probate process, there's estate administration that happens similar, like I said, kind of winding up my life in the way that you would wind up a business. But if you use a revocable living trust, you don't necessarily go through the probate process with the court, but there's still an administration. There's still an administration of that trust. So you either utilize the will and have the executor gathering assets, paying creditors, and making distributions and kind of filing any tax returns, et cetera. Or with a revocable living trust, you have the successor trustee who's pulling all the trust assets, looking at the terms of the trust to determine which beneficiaries those assets are going to go to, paying all the creditors, and then ultimately making those distributions either, to the individuals, to charities, to other trusts for individuals, et cetera. The point is, there's some administration in either when you use either tool. It's not that you use a revocable living trust and you're avoiding probate and there's no administration. You still have to administer the assets after death. So we mentioned probate, and we talked a little bit about what that is, but it is basically in a word is a court supervised process of settling a deceased person's estate. So you're transferring assets, settling up debts. That person has the authority to sell my house, set up trusts under my will if I've provided for that for my minor beneficiaries, for my surviving spouse, et cetera. So again, gathering assets, notifying creditors, filing tax returns, that's the probate process. And one of the things to think about is what assets go through probate, so to speak. If you own real estate, that's going to require a probate. If you have a revocable living trust as your primary planning tool, you can title your real estate in the name of the trust, and then it's administered as part of the trust. Then you don't necessarily have to utilize a probate. These other assets are things that can go through and pass via contract designation, essentially. So if you have a bank account, this often comes up where it's a joint tenant with rights of survivorship with a spouse, with an adult child, or someone else. If you have property that's subject to a community property agreement, assets that are held in trust, life insurance policies, or transfer on death or pay on death accounts, any assets that have their own beneficiary designation that's actually designates a beneficiary on it, or they're titled with rights of survivorship, those assets will pass automatically. They don't go through probate in the way that real estate, or if you have a bank account that's just in your name and doesn't have a designated beneficiary or a joint owner on it, then it will pass through the probate process under the terms of your will if you have a will-based plan. In terms of just kind of thinking a little bit more about the tax planning piece. So we talked a little bit about estate taxes, gift taxes at the outset of the conversation, and talked a little bit about making some lifetime gifts because Washington doesn't have a gift tax. But when you're doing some kind of fundamental or foundational estate tax planning under the terms of your will or under the terms of your revocable living trust, particularly for married couples, setting up a trust that is called a credit shelter trust under the terms of your will or under the terms of your revocable trust. This isn't something that's standalone that you set up during life. It's something that you bake in, you build into the terms of whichever foundational type of document you want to use. You build those terms in so that, for example, I mentioned that Washington has this $2 million exemption amount per person. So for my husband, Nick, and I, under my will, I die, and $2 million of assets, if I have that at death, is going to flow into, so my half is going to flow into this trust for Nick's benefit, where Nick serves as his own trustee. Nick has access to those assets during life in the same, very similar way that he would have access to them otherwise. But what happens is at Nick's death, he gets to use his own $2 million exemption amount to pass assets from his estate to, our beneficiaries. And he also has preserved my $2 million exemption amount utilizing that credit shelter trust. So he's able to use not only his own 2 million, but he's preserved my 2 million through that trust usage of that trust. The alternative is sort of what might better illustrate this. I die and nothing, my assets go outright to Nick, and say that we have $5 million in this example. My assets flow outright to Nick, then Nick dies with $5 million in hand. He gets to, there's no tax at the first spouse's death because of the unlimited marital deduction. So assets go to Nick outright, then he dies. He gets to use his $2 million exemption. So 5 minus 2 is 3. So he's got $3 million that are exposed to the estate tax for our future beneficiaries because he's only able to use his own exemption. Rewind the tape. My will says my share of the assets are going to go into trust for Nick's benefit and then, to ABC beneficiaries. I die, my half goes into the credit shelter trust for Nick's benefit, and Nick's assets are held, his share of the assets are held in his name. Then he dies. We've effectively used not only Nick's 2 million, but also my 2 million. So we take the difference between that $5 million, take away my 2 million, take away Nick's 2 million. We have 1 million left that's exposed to estate taxes for our future beneficiaries. And that's the way that trust language needs to work, or that I mentioned that if we utilize a trust in Washington under a will or under a revocable living trust, we're able to use both exemption amounts for married couples. At the federal level, what happens, whether that trust exists or not, is Nick would be able to file for portability and utilize my exemption amount. He would be able to add it essentially to his own exemption amount. But in Washington, utilizing that trust makes sense frequently at the federal level as well. But in Washington, that's the way that you utilize both spouses' exemption amounts is through that credit shelter trust language. And again, that's something that's either built into your will or built into your revocable living trust. We often talk about the unlimited charitable deduction. So I mentioned particularly with regard to the annual exclusion amount, you can gift as much as you want to charity during life, and you're not going to have to pay any gift tax on that. Similarly, if you're charitably inclined and you have charitable beneficiaries under the terms of your will or revocable living trust, then those assets that flow to charity are going to come out of your estate for estate tax purposes. So one really efficient and really good way to manage potential estate tax exposure is with your own charitable intent. So remembering those nonprofit organizations during life, and then also in your estate plan via your will or your revocable living trust. Some folks will choose to utilize their retirement plans, particularly for IRAs, having charitable beneficiaries as the designated beneficiary on those is a most tax efficient way to pass those assets if you're charitably inclined. One, it takes it out of your estate for estate tax purposes. And two, because the charity is going to get dollar for dollar distribution from those accounts without having to pay any income tax on the built-in income from those distributions. Whereas when an individual takes those distributions from an IRA, they take the dollar distribution, but then they also have to pay the income tax that's built into that dollar. So whatever percentage of that dollar is actually income, they're going to have to pay income tax at the distribution point. And then one last thing that I wanted to mention, because I've seen this coming up very frequently with clients, particularly when they're charitably inclined, is oftentimes folks will say to me, I have, they have 10 charities that they support during life, and they want to remember them at, varying percentages under their estate plan. But then they're, sometimes things change, and sometimes leadership changes, sometimes the organization changes, sometimes their intent changes. And they say, they're calling me to make updates to, we're taking out ABC charity and we're adding XYZ charity. And one thing that I found, and I know that this is something that is easily utilized through Seattle Foundation, is working using a donor advised fund. And I frequently have been telling clients, because they do offer a significant amount of flexibility where they don't have to call me to update the document, is utilizing a donor advised fund, either that's going to be set up at death under the terms of their directives, or it's set up during life, in which case they can easily make changes to the varying charities or charitable types of charitable organizations that they want to support, rather than having to call me and say, I need to update my will again, Tiffany, from ABC charity to XYZ charity. If everything is going to flow, all the charitable assets are going to flow through to a DAF, then they have the ability to make those changes, simply by picking up the phone and calling their advisor rather than updating their will. So that was one other charitable thing that I wanted to point out. And then finally, when should you consider updating your plan? I tell folks, weddings, babies, and funerals, liquidity events, any big life events, you want to at least stop and say, hey, do I need to think about making a change to my plan? I have, a significant increase in wealth. So suddenly, I've sold a business, or I've otherwise, come into a significant amount of money. I've received an inheritance, and I want to make sure that my plan still works, even though my assets have increased, or the value of my assets is increased. Somebody dies. Again, you inherit funds, or you lose a spouse, or, any immediate person in your family, with the death of a family member, thinking about, does this do anything or make any, do I need to make any changes to my plan? Similarly, having children, increasing the size of your family, does that in and of itself, you have grandchildren now, or similar, you want to just make sure you stop and think, okay, maybe it's worth picking up the phone and checking in with my advisor to say, hey, this has happened. Do you think we need to update my plan in any way? Similarly, if you get a divorce, wanting to make sure that your beneficiary designations are updated, and making sure that any estate planning documents are updated to make sure that they affect your current intent. So with that, I'm going to pull up a couple. I see that there are a few questions in the Q&A. And
yeah, it's time for Q&A. Don't forget to put your questions in the Q&A box if you haven't already. We'll get to as many as we can. I think Natalie's going to kick it off, Tiffany, with a question that someone emailed us before the event.
Oh, perfect.
Yeah.
Yes, let me do that. Thank you so much to this person who submitted this question. Okay, so our first question for today will be, what sort of family arrangement and estate size is best served by a simple will, power of attorney, and healthcare directive? I think you've touched on this a little bit.
Yes. So I think that one, anyone over 18 really should have a durable power of attorney, because that's the age at which you're able to say, this is who I want to manage my finances, big or small. And this is who I would want to assist and give direction with regard to healthcare if I were in a position where I couldn't do it. And I see this a lot of times with clients, children who are graduating and going to college. So I've got a number of them coming in actually later this week and next week to sign their powers of attorney because they're heading off to school. So thinking about that as kind of rule number one, once you're 18, you really should be able to give, or you can give the direction, and you should take that to be able to appoint who you would have serve in those roles. Um, and with regard to a will, um, you know, you could have a Buick and a base fiddle, and you don't have any real property in this scenario, but utilizing a will to make sure that you have a guardian or conservator appointed for minor children, or just to give direction where that Buick and base fiddle is going to go, who you would want to receive your assets, tangible personal property, even though some of those things are not high value, big ticket items, it's still your belongings, and making sure that you have the ability to give direction as to where those things go. Similarly, under the terms of your will, you appoint the executor. So you have the opportunity to say, this is the person who I want to deal with my things, even though they're not a high significant value. Similarly, from soup to nuts, from, a small, very small estate, like the example I just gave, all the way up to I have multiple millions of dollars. A will still works. When I tell folks that they might want to consider a revocable living trust as an alternative is really if they own out of state real estate. Because if I have property in Idaho or Oregon or any state that's not Washington, then you get into a place where you say, okay, I have to do, or my heirs, my beneficiaries, my executor has to do a probate in Washington, but then also in these other states where the real property is. So that's really the key time that I would tell folks utilize a revocable living trust, or at least consider it, rather than a will, is if you are in a position of your executor having to do multiple probates in multiple states. It's not insurmountable, but that's the time where I say that could actually make sense. Sometimes folks will tell me, oh, I moved from California, and so they already have an existing revocable living trust. Well, at that point, rather than, changing title to all of their assets, it might just make sense to utilize the document that they're used to, do an amendment and restatement of that document under Washington law. The trust name doesn't change. They don't have to retitle their assets again. They're able to just maintain that same trust, but now they're maintaining it under Washington law. And so there are some times where a will, always I think it always makes sense, but there are some times where it might be a little bit more appropriate to utilize a revocable trust. But those are really, those couple of scenarios that I mentioned. But at the end of the day, it's your tool. And so if you say, I like a trust because I like a trust, that is good enough for me. As long as you understand the differences, and you say, you know what, I'm selecting a trust as the tool because I just prefer it, or I administered one for my parents and so I'm familiar with it, that's a fine enough reason as well. But when I would say really consider utilizing it, when I would encourage someone, is really that real estate time, when they out of state real estate.
Okay, great. Thank you. I have two questions that are related to exemptions. So the first one I think is a quick one, is the Washington estate tax exemption per person, like the federal exemption. And I think the answer is yes.
Yes.
That was Dawn. And then Gwen asked if the federal exemption amount based on tax law that it will sunset in 2025 unless renewed? And if so, what is the reduced exemption?
That's a great question. So yes, so currently, if nobody does anything, meaning our friends in Washington don't make any changes, then what will happen at the end of 2025 is the current provisions will sunset. And so we'll be back to an exemption amount that was historically $5 million. That's going to be adjusted for inflation. And so really the number would be closer to about 7 million in today's dollars. And that's if nothing happens. I don't know if something will happen. So we might, we're all waiting with bated breath to see, what's coming next. But if what is set to occur occurs, that's what the climate and what the landscape will look like.
Natalie, you have another question?
Yes, I can do our next question. So our next question is it generally more or less convenient for a representative living out of state to handle either a will or a revocable living trust of someone living in Washington?
That's a great question. We are very much global these days. I feel like none of us lives exactly where we grew up for the most part. And so we are scattered all over the country and really all over the world. So thinking about the ease of administration for your fiduciary it makes sense, and it's a good question. I think that given the way that we do things now, and all assets being equal, so say you have a residence that needs to be sold, well, your executor is going to sell it either as part of the probate, or your successor trustee is going to sell it. They're going to deal with the real estate agent. They're not necessarily going to physically need to be present. They might need to come out here or get people that are boots on the ground to clean out the house, to to remove tangibles, to go through those things, whether that house is owned by you as an individual and is transferred under a will, or if it's owned by you in your trust and they become the successor trustee. I really think that logistically, they are six of one, half dozen of the other in terms of the ease with which they can manage things from afar. There are some tasks that you may say, oh yes, this person's definitely going to want to be here going through the boxes in my attic, etc. And that's going to be true whether it's a trust or utilizing a will, and then there's a probate. But even dealing with third parties, I'm just thinking about them dealing with banks or financial institutions. If you are an executor under a will, then you get appointed by the court, and the court gives you what's called letters testamentary, which is a one-page document that says Tiffany is the executor of Mr. Smith's will, and she has the authority to act. Similarly, under a trust document or trust agreement, there's an appointment of a successor trustee, and they're telling financial institution in the same scenario, I'm a successor trustee, I have access to this trust account. So I don't think that one over the other is really easier from out of state.
Okay, well, it's almost time to close out. Before we do, there were two questions about donor advised funds. Mary asked, who or what does one set up a donor advised fund with? And I just wanted to make sure and be clear that Seattle Foundation does provide that service, and we'd be happy to talk to you more about that offline. And then there was another question about the fees charged for distributing those donations, and that really depends on the amount of the distribution. And so again, happy to talk more about that in your specific situation offline. First off, I just want to, before we officially close, thank you, Tiffany, so much for taking time out of your busy schedule to be with us today and answering all of these important questions. I want to remind everyone that after the webinar ends, a survey will just pop right up on your screen, and we really hope you'll take time to fill it out. And if you do, you'll get entered in to win a prize, so don't forget that. And then finally, we'll be sending out all of the slides and a copy of the recording early next week, so look for that email from us. And don't forget that, leaving a charitable bequest is one of the most meaningful ways you can support nonprofits in our community, and Seattle Foundation is here to help with legacy planning and ensuring that you make a lasting impact with your philanthropy. If you have any remaining questions that didn't get answered, please send them either to Natalie or myself, and we'll follow up. And I just want to thank you all for coming today, and to take care. Thank you so much.
Thank you.
Thanks, everyone.